May I please your lordships?
Yes.
Also, I beg to item number 23 and 24, my lord.
Today's list.
This is an appeal, my lord. We have filed an IA, lordship. But in 24, on last occasion, my lord, on 2012-3-2026, lordship, we have withdrawn the Wakalatnama with a prayer to strike off our names. So, my lord, there is a direction in that case, but still our name is showing, my lord. So, my prayer to strike off the names of the earlier sets of councils, and there I contacted the appellants, my lord. They informed that by today or tomorrow they are going to engage the under the states of advocate, my lord.
What is your
24?
your good name?
My name is SK Nargis, my lord.
Nargis. Your their name is shown in IA, then the criminal appeal, both the appeals, isn't it?
Would appeal, but in 24, this prayer regards to item number 24, man.
24 only.
No, only
23 will be appealed.
23, my lord. We have filed an I am still in that case, my lord.
Okay.
We have filed an IA, and this honorable court passed a direction to file an objection by the opposite party, my lord. He informed that he will file within a week. My prayer to take up this matter on Monday, next Monday, my lord. 8.
Item 24.
24. 23. Both are analogous matter, my lord, out of same judgment.
Okay, you'll be appearing in 23,
Yes,
but you want your name to be struck off from item 24.
my lord.
Okay. And IA is in connection with item 23.
23.
Okay. You are there for?
Well, I'm additional
For the state. You'll be filing your objection.
Yes, madam.
IA is for what? Suspension?
Suspension of sentences.
Okay. So, Monday. Please write, Miss S.K. Nargis, Learned Counsel, submits that she will be representing the appellant only in criminal appeal number 187 of 2025. She submits that on the last occasion, there was an order for striking off her name from the arrayed counsels in criminal appeal number 441 of 2024. But her name has still been reflected. She prays for her name to be struck off. She also submits that she has been informed by the appellant that she will be engaging separate set of counsels in the matter. Stop. Next para. Mr.
R.R. Kaushik.
R.R. Kaushik. Learned Public Prosecutor.
Public person.
Additional public prosecutor. Additional Public Prosecutor. Appearing for the state submits that he may be given a week's time to file objection to IA criminal number 532 of 2026, which is an application praying for suspension of the sentence imposed upon the applicant. Stop next paragraph. View of name of Miss S.K. Nargis be struck off as the counsel for the appellant in criminal appeal number 441 of 2024. And these matters be listed again
8th of June.
on 8th of June, 2026. Stop in the meantime. State may file their objection to the IA. You so advised. All right.
This is your lordships. I'd like to mention item 29. It is a matter appeal. I pray for an adjournment.
29.
29.
You are
I am the appellant.
you are the appellant.
Yes.
Why do you want adjournment?
My senior is out of station.
Who is your senior?
MS Chaudhary.
M.A. Chaudhary.
Yes.
Last time also same thing happened. It was adjourned on your prayer. Again today.
My lord may fix it on next week, any day.
We'll fix it, but again you'll adjourn it again. Like that, you'll go on and on. Do you have any case?
Yes, your lord.
Is there any merit in the appeal?
Yes, your lord.
Huh? Marriage by force. You've seen it. The, the girl has filed for divorce, okay? And she says that the fellow, he tricked me. He said that he'll do something and all that. And took me to Calcutta to get a job once he went to Calcutta. Okay, who's for the other side?
I have taken consent from the other side.
Who's that other side counsel?
R. Fukan.
R. Fukan. Okay, so when do you want it? When is he coming back, Mr. Chaudhary?
Your lordship, on 15th of June.
You're not sure. You're just seeking time like that. You're not sure. Okay.
I'm not sure when he's coming back.
I'm not sure, but
Okay, your good name?
T. Chaudhary.
Sorry?
T. L. Chaudhary.
L. Chaudhary. Oh, TL.
T. L. Chaudhary.
Mr. TL Chaudhary, learned counsel for the appellant, submits that he is led by Mohammed M.H. Chaudhary, learned senior counsel
Yes, your lordship.
in the matter. And since he's out of station, he prays that the matter may be adjourned and listed again on 15th of June, 2026. He also submits that he has taken the consent of the other side. That is Mr. R. Fukan, appearing for the respondent. Next para, considering the above, matter stands adjourned to be listed again on 15th of June, 2026, with an understanding that the learned counsel for the appellants shall not seek further adjournment. Okay?
Highly opposed.
Right, make it 16th, Tuesday.
Highly opposed.
Yeah, please, your lordship.
Yes.
Lordship, I beg to mention item number 3. Your lordship. Reading out of Mr. HMY is if he's unable to appear.
3 means 3 to 13.
Yes, lordship. Yes, 3 to 13. lordship. List is already, this honorable court has already, one issue was corporate and fight order is 10 to 2025. Was prior to the opinion that this appeal are not maintainable in view of the fact that learned single judge have passed these orders in exercising our power under the Article 227. And accordingly, the amicus curiae was appointed, lordship. These issues are already hard, lordship, and pleadings were already completed. So, lordship, we are also led by learned senior counsel P.K. Goswami. He has also some personal difficulty.
You are seeking adjournment on whose behalf?
For Mr. HMY, your lordship. In
H.
item number
Chamoa. H. Chamoa is for the respondent number 4 and 5.
4 and 5 in item number 3.
What do you want?
Any date, your lordship. as your-
Any date means?
After a week or so.
There are so many dates this year, 2026. So many dates are there. Which date?
Your lordship, any day after a week.
After a week.
So, that is- After.
If can we fix an application?
For the item number 10.
Yes.
I am for the item number 10. My matter that is segregated from the. My matter is something different. I'm relying on the never take. It's fairly comes under the. It's not.
Which item? Item number
Item number 10.
10.
For one.
Correct. Your good name?
Did appeal.
You-
So we did that.
What is your name?
Have 10.
Okay. See, since adjournment is sought and all these matters have been clubbed together, and we are aware of the fact there's an administrative order
Yes.
of the Honorable Chief Justice
Yes.
saying that this matter has been allotted to us.
Yes.
So let us have it sometime next week, probably on Thursday. Parties should make it convenient. We should not adjourn it for a long time. Say 11th of June,
11.
it's a hearing date.
Yes.
On that day, we'll consider whether to segregate or decide separately and all that.
Yes.
Okay?
So first preliminary issue has to be decided thereafter the matter will.
All right, we'll see.
Same issue is regarding 11 also.
Huh?
And 11 also, my lord. In fact, Supreme Court, when the petition is also not maintained. Because that was regarding preliminary issue of fairness of domestic. In case of domestic, fairness of domestic inquiry, preliminary issue is decided against the management. Management has the option to lead evidence on meeting. That was allowed. But it was, by that petition, it was stored. Supreme Court in, for engineering state that, it cannot be stored.
All right, we'll see.
Yes, yes.
We'll just list it on that day.
So the 10 matters start together, but the issues are big.
We understand that. We'll decide that on that day. Okay? Please write, parties are represented by their respective councils and has agreed to list these matters for admission hearing on 11th of June 2026. Sub-learned counsel, Mr. F. J. Majumdar, appearing for writ appellant number, appearing for the appellant in writ appeal number 152 of 2024, submits that this matter can be segregated since the issue is not similar with the rest of the writ appeals. So be that as it may, the same will be considered at the appropriate time. List accordingly.
May it please your lordship, I will mention one criminal appeal for listing. Lordship kindly short date may be given.
What matter?
Criminal appeal.
Appeal. A new, fresh matter,
No lordship, it was listed on 2025.
2025.
It's not a fresh matter.
What do you want it for? Listing for?
It's a, lordship, it's a POXO matter.
Fine, that's fine. You want it for hearing, admission, or what?
Orders, for orders.
For orders. Paper book is ready.
Yes, lordship.
All right. Give a date. 36.
Of high school.
Permission item 1. My lord, before I proceed with this matter, my lord, in a similarly situated case, my lord, appeal, we had filed recently on the same grounds, my lord, and on the same set of facts, my lord, before this honorable court, under section 49 of the PBPT Act, it is Prohibition of Benami Property Transactions Act, my lord. Here, my lord, a coordinate bench of this honorable court had already decided the questions of law that we are raising in this current appeal, has already decided in that appeal. So we praise humbly, my lord, that this current appeal can also be made squarely covered by the, my lord, the judgment and order passed by this honorable court. Kindly lordship may come.
You
to that
have
order.
annexed that
Yes, my lord. Yes.
decision.
Yes, my lord. If my lords may kindly come to page 125 of my appeal.
125.
My appeal, my lords.
ITA 1 of
Yes, my lord.
2026.
So
You say it
here-
is covered by this judgment.
Yes, ma'am, because the appellant in ITA 1 are, my lord, these are all benamidars. The current appellant is also one of the benamidars. So the present set of appeal was filed against a similar impugn order, wherein, my lord, a review was allowed. My lord, a review was allowed by the appellate tribunal by not conforming itself to the statutory norms and the requirement under Order 47, my lord, Section 114 of CPC, and, my lord, also ignoring the aspect that under Order 47 Rule 1, there is an explanation that if an order of this court or any decision of the court has been rendered by a court and as a question of law has been framed, subsequently, the same decision, if it is altered or modified by different court or a superior court, my lord, that cannot be a ground for review because the law has already been, my lord, framed by the earlier court. So by ignoring explanation 1 of Order 47, this review, the impugn order was passed. So we approached this honorable court by saying that order was wrong, my lord. And there were other coordinate, my lord, there were other, my lord, judgments of the Honorable Apex Court, which was already holding the field. That, my lord, the court cannot proceed by reviewing this order, ignoring explanation 1 to Order 47 and Rule 1, my lord. Any lordship may come to the operative part of this order, if I may take.
No, review was sought. Review of which order?
But the current impugn order that we are challenging before your lordship, my lord, has been passed by the Honorable Appellate Tribunal in New Delhi, my lord.
Right.
So a similar
Allowing review.
allowing the review filed by the
So-
Income Tax Department.
Right. Which order was reviewed? What was that order that
Yes,
was
my lord.
reviewed?
The original order which was reviewed
Hmm.
was the order which was passed by the authorities for proceeding against us under the Act. The core issue was before the authority was that, my lord, this Act was in fact amended in the year 2016. The Benami Act was amended in the year 2016. A major amendment was brought to this Act of the year 2016. And while amending this Act, my lord, there were some provisions which made which introduced certain penal provisions and enlarged the definition of Benami transactions, which was missing in the earlier Act, my lord. Now, the amended Act also incorporated the aspect that the amended portion will be given a retrospective effect. Now, this application of retrospective effect to the amended provision was challenged before the Honorable Supreme Court, my lord. Now, Honorable Supreme Court in one important case, my lord, Ganapati Telecom, which is a very much part and parcel of this particular issue that we are raising today, has observed clearly that you cannot give application to penal provisions by applying it retrospectively, meaning thereby all transactions that had taken place prior to 2016, all Benami transactions, my lord. So those Benami transactions cannot be brought under the purview of the Amendment Act because it violates clearly Article 21 of the Constitution. Because at that time, prior to 2016, any Benami transaction that has taken place, because there was no law at that time to hold such transactions as Benami, my lord. So Supreme Court in
So the law was brought that will apply retrospectively.
exactly.
And Apex Court said that it cannot apply prospectively.
It
It
should
can apply
should be
retrospectively.
prospectively.
It'll apply only prospectively.
Prospectively.
So now,
Cases, my
Ah.
case was, but my lord, whatever transactions they have, my lord, identified Income Tax Department were all of the year prior to 2016. It was in 2015, a search and seizure was conducted. In the search and seizure, I was one of the person who was, my lord, found to be connected with the major accused person who was the beneficial owner. I was one of the benamidars.
you were the opposite party in the review petition.
I was the opposite party review petition. my lord.
Review was allowed.
Review was allowed.
So
So there-
against that, you've come.
yeah, I have come against that. And now, my lord, today also, I am one of these benamidars here. And today, my lord, as because this honorable court has already dealt with that issue in a coordinate bench of this court, my lord, which I have just submitted.
Right. See, I think your case basically is that you're covered by this judgment.
Yes, my lord. Basically, it's
So,
covered by judgment.
No, so if the opposite, this has come for the first time,
Today has come for first time, my lord.
will you issue notice?
My lord,
Let the opposite
difficulty-
party also examine and say
No,
what.
one
they want.
aspect is there, my lord. The difficulty is there, my lord, as the coordinate bench has already decided on the very first day when the other appeal was decided,
Ah.
we have a pending proceeding which is pending in the appellate tribunal in New Delhi. If your lordship is pleased to proceed with this matter and examine whether this is applicable or not in my case, the coordinate bench judges, then I will pray my lord humbly to stay the proceedings which is pending before the the court in, before the appellate court in New Delhi. my lord.
What is that matter pending
That is the matter which has reopened
after that review?
after a review, because again Supreme Court came, my lord, and the Income Tax Department filed an appeal, filed a review of the original Supreme Court order. That is Ganpati Ilcom order was again reviewed by the Income Tax Department. There, what Supreme Court did on a very technical ground said that since the constitutional validity of the provisions was not put to challenge, that is provision of application of that particular law, whether it should be applied prospectively or retrospectively, so the court allowed the review of its own
Okay.
order.
Okay, then,
Court allowed the review, meaning there, my lord, it did not basically completed the case, but the case is still pending before the Honorable
it's
Supreme
still
Court,
pending.
and gave a liberty to the authorities, Income Tax Department, then you can go ahead and file reviews in your respective cases that is pending in your
Okay.
appellate courts.
Okay.
So that is why this, my lord, the
Okay.
Income Tax Department, they filed a
Okay.
review.
At
It-
what stage?
My lord.
At what stage did the apex court say that it cannot be applied retrospectively? It was an interlocutory order,
My lord,
not a
that-
final order.
my lord, that aspect is still under examination. Court only said, Honorable Supreme Court only said that the constitutional validity of that particular provision which speaks of application was not challenged.
No,
So
that came later on.
it does become,
Before that, court said that it cannot apply retrospectively.
that is
By
exactly-
which order?
by, yes,
Was it not a final order?
yes, Supreme Court has a final order.
It was a final order.
That is the ground, why, my lord, this honorable court has intervened and set aside the order of this appellate tribunal, because that is already a law. It has taken place, my lord. My lord, the earlier order of, my lord, may I kindly come to this order, my lord, page 136, my lord. I'll just read this paragraph number 19. May I read, my lord?
Yes.
The other issue that has to be decided as to whether the finality given to the issue by order dated 17/12/2022. This was the order passed in my favor by setting aside the earlier proceeding, which had been made on the basis of the judgment. This is the judgment I'm referring to. 23/8/2020 passed in Union of India, another versus Ganpati Dilcom, reported in such and such, with regard to the alleged Benami transactions that had allegedly entered into by Sri Pradip Kumar Saha with appellants on the basis of a search and seizure operations that had been conducted prior to the amendment of the Act of 2015 could not be reopened. In view of the review of the earlier Honorable Supreme Court judgment being allowed by the subsequent order dated 18/10/2024 of the Supreme Court in Union of India versus so-and-so Ganpati Dilcom in reported in 2024. Thus, the question of law that are to be decided are as follows: whether the learned tribunal acted illegally in allowing the review petition on the basis of liberty granted by the Supreme Court without examining whether such liberty could override statutory limitations under Section 114, read with Section Order 47 and Section 40F of the PBT Act. Whether impugned order allowing review application is in teeth of the express bar set forth in explanation in Rule 1 of Order 47. As can be seen from the order dated 19/10/2024 passed in the review petition, that is Union of India versus Ganpati Dilcom, reported in such and such, the Union of India had been granted the liberty to seek a review of the order dated 7/12/2022 passed by the Learned Appellate Tribunal. However, in the case of KL Rathimalo, this is important, Supreme Court, while considering its other judgments, such as Subramaniam Swamy reported in such and such and so reported in such and such, has held that in terms of explanation to Order 47, Rule 1, if the decision on a question of law on which the judgment of the court is based is subsequently reversed or modified by subsequent decision of Superior Court in any other case, it shall not be a ground for review of such judgment, my lord. Therefore, even an erroneous decision, my lord, cannot be a ground for a court to undertake a review and that change in law or subsequent decision or judgment of a coordinate bench or larger bench by itself cannot be a ground for review. In paragraph 57 and 58 of the judgment of the Honorable Supreme Court in cases of KL Rathi are reproduced herein below as follows, my lord. This court in Subramaniam Swamy reported in such and such has read the explanations as follows. Explanation to Order 47, Rule 1 of the Code of Civil Procedure provides that if the decision on a question of law on which judgment of the court is based is reversed or modified by a subsequent decision of a superior court in any other case, it shall not be a ground for review of such judgment. This thus even an erroneous decision cannot be a ground for the court to undertake review. as the first and the foremost requirement of entertaining a review petition is that the order review of which is sought
Mr.
suffer
Burgoyne,
error.
I think that's sufficient.
Madam.
Then you come to paragraph 26, that is the decision.
Yes, the answer.
What do you say, madam?
Lordship, there are 2-3 grounds. Firstly, the instant appeal is not maintainable in its present form.
Why?
Reason being, the impugned order which is there in the instant case, though it is a common order, they were passed in 2 separate appeals. But the instant ITA has been filed as a common ITA. The case numbers, the appeal numbers are different. If I may take your lordships to page number 24.
24. You're saying the applicant has resorted to two-in-one appeal.
Lordship, there are basically 2 appellants. Before the appellate tribunal at New Delhi, one was case number 928 of 2019. And the second appeal was 978 of 2019
978, but where is that?
at page 28,
28.
24 and 28. These are the 2 orders.
Okay.
When the appeal was disposed.
978, is it?
Yes, Lordship.
978 and 928.
978/GWH/2019
978 and 928.
and
Two
928.
appeals.
So these are 2 separate appeals.
Okay.
So once the order is emanating in 2 different cases, before this honorable court also 2 separate cases ought to have been filed. This is the first ground. Secondly, Lordship, if I may take your Lordships to page number 25.
25, yes.
Lordship, the third last paragraph.
Hmm.
It is, however, submitted. Has your Lordship found?
Yes.
It is, however, submitted. This is the order posed off by the appellate tribunal. It is, however, submitted that the department has filed a review petition before the apex court in the case of Union of India versus Ganpati Dealcom Private Limited, reported in 2022 SCC Online SC 1064. Thus, if the appeals are allowed after governing it by the judgment of the apex court in the case Sutra, liberty be given to the department to take the appropriate remedies in case of review of the judgment by the apex court. It may include a review petition before this tribunal. Now, next page, Lordship, the last paragraph. It is, however, made clear. Lordship, the appeal was allowed and it was disposed of. It is, however, made clear that if the apex court reviews its judgment, the respondent would be at liberty to take appropriate remedy pursuant to it, which includes filing a review petition before this tribunal.
So,
So
apex
this
court reviewed the judgment.
this particular order is not under challenge.
Why?
And this order was duly passed in the presence of the appellants. The liberty was given in their presence. They did not object to it. The same thing has also been recorded by the learned appellate court in order dated 10/7/2025, which was a batch of separate review petitions. The order is at page 74. It starts at page 74.
What is that, 74?
Page 74, Lordship, similar cases were decided by the appellate tribunal. And on the basis of this order, the impugned order has been passed. Every single issue has been dealt in detail in this particular order dated 10/7/2025.
This is the appellate order, is it?
This is the appellate order. On the basis of this, the impugned order has been passed. The issues in detail have been dealt with in this particular order. If I may take your Lordship to page 78, para 5. The 6th line of para 5.
What is this order otherwise? It's passed in the review or in the appeal?
It's passed in the review.
In the review.
The review before the appellate tribunal.
Okay. So similarly, there were other review petitions.
Yes, Lordship.
And in the order passed challenge in this particular application is the order of review passed in the other review petitions.
In the second batch.
And it is based on basically of this, on annexure 5,
Yes, Lord.
on this order dated 10/7/25. So the tribunal said that no, there is no requirement of going into the matter once again. The issue has already been dealt with by this
Yes,
order
Lord.
10/7/25,
Yes, Lord.
hence the review.
My lord,
Yes.
yes.
Review order is very short.
My order at page 72, if your lordship may kindly come. The point which my learned friend is raising, that why I have not filed two separate appeal because of this reason, because the common order was passed in page 72, my lord. 72.
Maybe.
Yeah. So head ground, obviously, my lord, it's a technical ground she's saying, but it was a common order
See.
for order to appeal into the file.
In normal circumstances also, like we have common judgments.
Of course, my lord,
Mm.
of course, my lord. So,
Then,
so here, what my learned friend is saying, that the basis of passing this order was
Oh.
the order that was issued in another different case, not relating to me, on the same subject matter, perhaps, from page 74 onwards.
Mm.
But my point is not on this, my lord. We have a very different point that we're asking, that whenever you are raising a ground of review, you need to stay within the limits of 47 order and 114 and the explanation. Now, when this review was reopened, we have contended before the appellate authority that you cannot or could not have reopened the review because there is in fact no ground under the three ground that is given under order 47. That is error apparent. Number one is any additional new discovery of facts or materials. Number two, error apparent on the face of the record. And number three, any other reason. Now that is why explanation one comes into play, my lord. Because explanation one comes into play, that decision already taken by an honorable court under given facts and circumstances, which my lord, the materials placed before the court, and subsequently, if the decision is changed, my lord, that cannot change of decision is not a ground for review, my lord. We are on a very limited ground. The law has changed from A to B. When it was at point A, my lord, the benefits that I need to have under the final order, I have been given the finality. And therefore, at page, my lord, 24, the appellate authority, they themselves set aside the entire proceeding. At page 24, in my appellate order, first order, if your lordship sees, at page 24, the court, the appellate tribunal taking into note the finality of the Gauhati Dealcom coming into its conclusion and saying that it cannot be applied retrospectively, it has finally dealt with the matter. And the
Liberty was always given, Lordship. It
No,
was
no.
not dealt with finally.
Liberty giving is something different. If there was any apparent, then they have to see, and that is why, my lord, KL Rakhi case came into play. And one more judgment, my lord, I would like to place, my lord. A coordinate bench of 3 judges who had passed the order of review in Gauhati Dealcom. Prior to that, a 3 honorable judges bench of the same Supreme Court, my lord, has refused to entertain review. And that is why our court has observed in the order that a coordinate bench of a prior time of equal strength, because there are a number of judgments. If my lord, orders are passed by the same set of judges, my lord, then my lord, this seniormost or the judgment which is prior in time, which is given earlier, has to be given, my lord, relevance, has to be given importance, my lord. And that is why that judgment, which I'm relying upon, is reflected in the order. Kindly come to that order, my lord.
See,
At page 20, page 139.
Mr. Buragohan, I understand.
Yes, my lord. At page 139, well, I'll just read.
Madam,
that
you
part.
also, see, you will issue notice today. We will not decide it just like that.
Lordship, and we may be given an opportunity to file a written objection.
You file your objection. When can you file?
Lordship will try our best within 4 weeks.
4 weeks.
Lordship. Lordship, there is a similar proceeding going on before the Delhi High Court also. And one decision has already been rendered by the Rajasthan High Court.
That is all right, but we are concerned with our own High Court.
In-
This
in-
ITA 1 of 2026 is already there.
Interim is concerned, Lordship. As your Lordship has pointed out regarding issuance of notice, the Delhi High Court has also issued notice. And while issuing notice, the court has stated till the matter is further heard, the court needs to stay the final decision to be rendered by the tribunal. Let the proceedings continue. However, no final order shall be passed till further order.
Where
This
is
is
that?
the this
where
is
is
the order passed by Delhi High Court in a similar case.
My lord, may I just submit, my lord? At page 139, paragraph 25, it has been clearly observed that, my lord, may I just read, my lord, once more? As can be seen from
Just,
the
just a minute.
Order it is 10/7/2025, which the review order has referred. Where is the total?
My lord,
In your case, some order that is 10/7/2025 has been referred to. Yes, page 73.
my lord.
Page 72 is your order?
Page 72 is my order, my lord.
Yes, page 73.
73. Yes, my lord.
We cover the review application by the detailed order of 10/7/2025.
Yeah, but that is at page 74. It starts 74, then at page 76 is the relevant part. So what court did, had relied upon this 10/7/2025 order at page 76, my lord.
This 10/7 was also relied upon in the case, the earlier round of litigation.
No, this is a completely isolated, my lord, incident of some,
Is IPA 1 of 2026.
my lord. Yes, yeah, it was very much,
IPA 1 of 2026.
yes, of course, my lord.
That order which you challenged.
Yes,
It
Lord.
had also relied upon
Yes,
10/7/2025, we did not find it in the order reflected.
Yes, ma'am, yes. So this page 76 order was also very much part and parcel of that impugn order passed earlier, my lord. In this.
And Lordship,
judgment.
in page 78 of this particular order, it clearly says that it is after noticing the judgment in case of Ganpati is pending consideration on a review petition before apex court. And therefore, both the parties consented that whatever issues are involved in the appeal be kept open while disposing of the appeal in light of the judgment supra. It was a consensual order.
Para which one? Page 7.
Para 5, page 78. The sixth line.
This has been taken care of at page 131.
Lordship, in that also, I have one reservation.
I have for at page 130.
Yes,
All the
Lordship.
reservations in
Lordship,
order.
I am trying to distinguish a little bit on that particular judgment. And my first submission on that judgment would be the Income Tax Department has already taken steps. SLP is in the process of filing. That is in the
Page
process of-
132, whatever you read us in the earlier you read out.
Lordship,
That the
the-
export DB, if the export DBs is just when this will be done, that will be done. All this will be taken into account by the earlier order of this.
Yes, ma'am.
It's a full matter.
Yes.
Lordship, but SLP is in the process of filing, Lordship, in this matter.
So bottom line is we'll issue notice, you file your objection,
Lordship.
there'll be stay.
Then
Lordship,
I have
the
filed.
final order.
No, my lord,
Passing
stay
of
of the
final
proceeding.
order may be
Stay of
stayed.
the proceeding because the coordinate bench has already set aside the proceeding.
Because Lordship.
Even then, why
Things are going on.
why have a man or a person to undergo a process of
Yeah.
litigation? When there is a judgment of this.
Correct, ma'am.
Coordinate bench, we can
Correct.
rely upon.
Okay.
As of
Yes. My lord, we have filed an IA to that effect for granting us a stay, my lord, for staying the entire
There's
proceeding.
an IA also.
IA for stay, my lord, it's a requirement under law to file a separate IA for stay. My lord, it's the same ground we have taken in the main appeal, just for separate IA we have filed.
We'll pass a common order in the main, we'll
Yes, ma'am.
dispose of the IA.
Yes, ma'am, yes, ma'am.
Art Mr.
Submission
H.
may be recorded that two separate appeals ought to have been filed.
No,
Art Mr. H. Budagohain, learned counsel for the this is what appeal,
yes, my lord, IT appeal.
appellants, by the appellants.
Yes, my lord.
Who submits that by filing this appeal under section 49 of the Benami Transactions bracket Prohibition Amendment Act, 2016. The appellants have challenged the common order dated 5/1/2026
In the amendment.
passed by the Learned Appellate Tribunal at New Delhi under the provision of Benami Property Transaction Act from 1988 as amended in respect of MP-PBT. I'll repeat again, MP-PBT-938/GWH/2025 bracket review. MP-PBPT 939 slash GWH slash 2025 slash within bracket COD. What is COD?
That is what I'm so sorry, my lord, even I'm not acquainted with.
Close bracket in FPA dash PBPT dash 928 slash GWH slash 2019.
My
And-
it is condonation of bill, I'm sorry, my lord, she told me.
Okay. And small Roman 2 bracket, huh? MP dash PBPT dash 964 slash GWH slash 2025 bracket review. MP dash PBPT dash 965 slash GWH slash 2025 slash bracket COD in FPA dash PBPT dash 978 slash GWH slash 2019. You'll get in page 1, okay? First title. The Learned Counsel submits that the challenge made in the instant appeal is clearly covered by the decision rendered by this court in ITA number 1 of 2026 bracket Satyajit Saha and 9 others versus Union of India and 3 others. Rendered by order dated 30/1/2026, which is also annexed as annexure Roman 6 to the instant appeal. The Learned Counsel therefore submits that the impugned orders may be set aside. And pending final consideration, an interim order may be passed staying the order dated 5/1/2026 passed by the Honorable Appellate Tribunal. Next, at this stage, Miss, your good name?
Dr. P. Agarwal.
Dr. P. Agarwal, Learned Counsel. Appearing for the Income Tax
Yes, Lord.
Department submits that the appellants ought to have filed 2 separate appeals in view of the fact that there are 2 proceedings involved, namely FPA dash PBPT dash 928 slash GWH slash 2019 and FPA dash PBPT dash 978 slash GWH slash 2019. Now, however, for reasons best known to the appellants, they have filed 1 common appeal, which otherwise would not be permissible. She further submits that the order dated you are referring to that what with the knowledge of the parties you said? What was that?
10/7/2025.
Page?
Page number 76, the order
Okay.
starts.
The Learned Standing Counsel further submits that the order dated 10/7/2025 was passed by the appellate tribunal. Where is that observation?
Para 5, page 78. Sixth line. It is after noticing that judgment in the case of Ganpati is pending consideration on a review petition. before the apex court, and therefore both the parties consented that whatever issues are involved,
I would have.
not a party in that, but on the basis of this order, the order has been passed in
Then
the review. Lordship,
How can?
Without their consent. And their
Lordship,
consent
it is there in
consent
ours
is-
also, page number 20. Page number 25. They have never raised any objection when liberty was.
Someone, some other case, some people consented. Court is, the tribunal is imposing that order upon them.
Yes.
Their consent is not required.
But
Then-
Lordship, there is no objection when liberty was sought as well.
How could there be? They could not, they have
Page number 25, Lordship.
absence of consent. The dissent, absence of consent. I don't consent.
There is no objection at all.
You rewrite that
We were
part.
not even party. to
And
that
this
proceeding.
order,
My friend
this
is
order
afraid.
is not under
Alright.
challenge.
All right, just a
No,
minute.
but-
Some is that the order dated 5/1 I said, no? Instead you write, you cancel that. The order dated, in the order dated 7/12/2022, it was clearly observed that if the appeals are allowed after governing it by the judgment of the apex court in the case of Union of India and another versus Measures Ganpati Dealcom Private Limited, 2022 SCC Online SC 1064. Department would be at liberty to take appropriate remedies in case of review of the judgment of the apex court. To stop, she submits that since the apex court has reviewed the earlier judgment, the appellate tribunal was within its right to pass the interim order. Next para, considering the above projection, we are of the view that the matter requires to be further examined. And therefore, let notice be issued, returnable by 4 weeks. Ms. Dr. P. Agarwal, Learned Standing Counsel, accepts notice on behalf of
Respondent numbers 2, 3 and,
respondent numbers 2, 3 and
Lordship 2, 3 and 4.
2, 3 and 4. While who is appearing for CGC? No one. Finance Department. Government of India. Appellant to take steps for service of notice upon the respondent number 1 by speed post within 3 working days.
And I'll also serve an extra copy to the Central Government Council.
Extra copies be served to the learned counsels for the respondents within 2 days. Then you write, having regard to the projection made by the appellant, and also the fact that this court, white order dated 31/2026 in ITA number 1 of 2026 has taken a decision. We deem it proper that further proceeding we deem it proper that the operation of the common implement order dated 5/1/2026 be stayed till the next returnable date. The respondents will be at liberty to file their objection to the instant appeal. We so advised. List again on censor. C7.
I'm highly obliged. Deeply.
Then IA, you write, in view of the interim order passed in the main appeal, the IA stands disposed.
My interim order would continue the IO.
IA disposed.
Sorry. I'm obliged to. Highly obliged.
Jail appeal. What is done normally? Okay. Mr. Kaushik, what is this? No, what section?
My lord, I don't have the copy because.
Oh, you
they
don't have the
filed.
petition,
Yes.
okay, okay. There's a separate list for this,
Legal aid and amicus.
legal aid councils.
And amicus also there is a list. ma'am.
Amicus we have, but legal aid councils, is there a separate list?
There is a separate list.
Separate notification, but where is that?
I think recently one published. ma'am.
Hmm?
There is recently one published. ma'am.
For legal aid council?
Yes, ma'am.
Oh, yes, this is what it's called panels on. Panel lawyers. With the photographs and all that, is the one. Panel lawyers. We have to appoint, supposing we have to appoint a legal aid counsel,
My lord.
it will be different from the amicus, isn't it?
There are two lists, my lord.
Amicus is different, then legal aid will be from the panel lawyers.
My lord, there is a list for legal aid, my lord.
List.
Yes, ma'am.
And this matter is what? It's a POCSO matter. Please write down, this is a appeal from jail filed by the convict slash appellant against the order dated 24/12/2025. Passed by the special judge bracket POCSO, North Lakhimpur, in special bracket POCSO case number 57 of 2018, by which the appellant has been sentenced. The appellant has been convicted and sentenced to undergo rigorous imprisonment for 3 years for conviction under section 363 IPC and to pay fine of ₹3,000 with a default clause. Now further, the appellant has also been sentenced to undergo rigorous imprisonment for 14 years for his conviction under section 6 of the POCSO Act and to pay fine of ₹6,000 with a default clause. Now, next para, let the appeal be admitted. Issue notice to the state as well as to the complainant, public informant. Stop. Did I say call for TCR? Before that, you write admit, call for the TCR. Issue notice. Then Mr. R.R. Kaushik, learned additional PP, Assam accepts notice on behalf of the state. Relevant papers of the jail appeal we furnished to him within 2 working days. And the registry shall furnish the notice to be served to the informant of the complainant to the learned additional PP.
Yes, ma'am.
Who shall thereafter cause service upon the addressee to the jurisdictional officer in charge of the police station concerned. Most of the officer in charge of the police station concerned shall report back about delivery of the notice to the learned additional PP. Next para, we appoint Srimati Rita Das Govindra, Managing Council, as the amicus curiae to present the appellate. And also appoint Mr. Abdul Karim Azad as the legal aid counsel, who will present the informant public victim.
Rohit, regarding informal Rohit, receiving notice, if they don't appoint them, then
Okay, then you cancel the informant not request. You're right.
because
Only the legal aid, only the amicus curiae, okay? So, relevant papers we furnish to Srimati Rita Das Govindra, amicus curiae within 2 working days. List again on receipt of the PCR.
next time, Same,
This also,
we don't have a copy here.
also POCSO. Please write, this is an appeal from jail referred by the convict appellant against the judgment dated 27/11/2025, passed by the Court of Additional Session Judge, come Special Judge bracket POCSO, Sivsagar. In special bracket POCSO case number 13 of 2024. By which the appellant has been convicted under section 6 of the POCSO Act and sentenced to rigorous imprisonment for 20 years and to pay fine of rupees 10,000 with a default. Next, madam, the appeal be admitted for the TCR. Issues notice to the state as well as to the complainant public informant. Mr. R.R. Kaushik, learned additional PPSR, except notice on behalf of the state. Relevant papers. Be furnished to you within 12 working days. The registry shall also furnish the notice to be served upon the complainant public informant in the proper format. The learned additional PP who shall thereafter propose service of notice to the complainant public informant to the jurisdictional police station. Stop the is in charge of the police station concerned shall report back about the delivery of the notice to the office of the PP. Additional PP. As the legal as the amicus curiae to represent the appellant, the registry shall furnish the relevant papers in within 2 working days. List again on receipt of the TCR. Yes.
May I please your lordship? This is a bit peculiar case. What happened, your lordship? But other side is not here. Shall I start?
The other side is not here. NIA matter.
NIA matter.
This is an appeal against rejection of the bail.
Rejection of the bill because proviso says like that, the rules of the NIAS, 21, 4.
So in such case, appeal has to be filed, isn't it?
Yes, your lordship.
So hence the criminal appeal. Now, what has happened last time? Some objection was to be filed.
Because one of the co-bench, he has already dealt in the lower court.
I understand.
So
But
that is,
nevertheless, the NIA PP has to be filed the objection.
they have filed additional affidavit, we have received also.
Who's appearing? But where's the affidavit? Is it there?
One from Nia, one Mr. earlier Mr. Satyanarayan was there. Subsequently, on the last occasion,
When did you receive the copy? Because the copy is not available with us.
a few days back, Your Lordship,
Few days back.
on 29th. We have gone through the objection, the general objection is there, but if the Lordship will hear the matter, we are ready to argue the matter. But the problem lies, the other side is not present.
The second problem is the objection is not on board.
Okay, it is not on board.
So what to do?
As Your Lordship
Who is the
pleases.
counsel otherwise? Any standing counsel, any public prosecutor of NIA?
Mr. Satyanarayan.
Satyanarayan, okay. His name is, name is reflected somewhere?
Yes, Your Lordship in the, well,
This is item.
come here and they could date.
Karthik Chaudhary is there. Mr. Chaudhary is there?
If coming lordship, an affidavit has been filed on Friday, perhaps that is not on record lordship. That
Exactly.
is what I have
Uh-huh.
the instruction.
So who will be appearing? RKD Chaudhary.
Architect Chaudhary.
So when do we list it then?
This week, not this week, next week.
Madam, your good name?
M. Kumari, Manorama Kumari.
M. Kumari.
Yes, Your Lordship.
But your name is also not there.
Yes, I have filed Wakalat Nama. Name is not reflecting probably.
D. Nandi is there.
Yes.
M. Kalita is
My immediate. Wakalat Nama is very good. Well, 12 years of.
May I please have it?
Yes, Your Lordship.
Hmm. Okay. Okay. Then you referred it to the logical. It hasn't been decided.
इमीडिएट मेरा कुछ नहीं है फिर मैं जाता
Ms. Dean, please write. Ms. Dean Andy, Learned Counsel, appears for the appellant and submits that she has received a copy of the objection filed by the respondent. We however see that the objection is not on record. Yes, madam.
And Devi Lordship, we have filed the affidavit on 30 Lordship on Saturday.
Still Devi, Learned,
I'm appearing on behalf of Mr. R.K.D. Chaudhary, Lordship.
Learned Counsel appearing on behalf of Mr. R.K.D. Chaudhary. Learned TSGI submits that affidavit. The objection has been filed on when, Saturday?
On 35.
On 35/2026.
20. We have received on 20.
But we have filed on 30.
Office to verify and connect the same to the record and to list this matter again on
If convenient, Lordship, 12th of June. If your Lordship is convenient.
June. Okay.
Much obliged.
Okay.
Yes. Appeal against conviction under section 6 of the PROCEEDINGS. First time.
First time.
What's the first one? Any delay? There's no delay. No delay. So we'll admit it. Heard, Mr. Wait a minute. P. Award, Learned Counsel for the appellant who submits that this appeal is filed by the appellant against the judgment and sentence order dated 26/3/2025, 26, sorry. I repeat, 26/3/2026, passed by the special judge POCSO, Sonitpur, Assam, in special POCSO case number 143 of 2023, by which the appellant has been sentenced to undergo rigorous imprisonment for 20 years and to pay fine of rupees 10,000 with a default clause. Let the appeal be admitted. Call for the TCR, issue notice to the state as well as to the complainant, public informant. Mr. R. for particular additional PPSR accepts notice of behalf of state. Registry to furnish, no, appellant to furnish a copy of the memo working within 2 working days. Registry shall furnish another additional PP. The notice to be served to the informant of the complainant within 2 days, and the same shall be served to the complainant of the informant to the jurisdictional police station of the officer in charge of the police station, and thereafter report back about delivery of notice to the office of the additional. Lordship, there's one IA as well. Why this one?
For informants, let the notice go possible.
Okay. All right, all right. List again on receipt of the TCR. Then heard Mr. So-and-so, Learned Counsel for the applicant who submits that by filing this application, the applicant seeks suspension of the interim judgment and sentence dated 26/3/2026, passed in special bracket POCSO case number 143 of 2023. Pending final consideration of the connected appeal. Issue notice. Remaining will be same. Mr. Kaushik will appear, then notice to be served.
File objection.
Yes. The respondents may file their objection to the IA. So advice.
The appeal against conviction. Consider section
Conviction.
302
302.
to sentence to life. Sentence part is page 47.
There's no delay.
There is no delay.
Okay. Art Mr. S.D. Prakash, learned counsel for the appellate, submits that the instant appeal is directed against the judgment in order dated 22/4/2026, passed by the learned additional sessions judge bracket FTC Achar Silchar in sessions case number 8 of 2024, by which the appellant has been convicted under section 302 IPC and sentenced to imprisonment for life and to pay fine of rupees 20,000 with a default clause. Next paragraph, let the appeal be all for the TCR, if you notice to the state. There are particular additional duty exception notice on behalf of the state. Therefore, no formal notice is required. Extra copy of the appeal will be punished to him within 2 working days.
Mr. Respondent number 2 lawsuit.
Who's that?
Informant.
Okay. Also issue notice on the respondent number 2 bracket informant. Returnable by 3 weeks. Appellant to take steps for service of notice by speed post within 3 working days. List the matter again on behalf of the TCL.
Eighteen has come off for lordship service, my lord. We've got the service report. Service report has been received, my lord. My concern.
Paperwork is
Yeah.
already ready.
OC Lahore Ghat PSD of law.
Anyone appearing for the informant?
No, my lord, nobody is appearing.
Will appoint somebody?
Lordship.
That's fine. Meeting, the conviction is in the section 6 and section 8. The paperwork has already been given. I, my lord, honestly urge that the bail petition has all along been pending, my lord. There is no bar in taking up that bail petition. Because, my lord, so far as the sentence of 3 years is already under. And section 8, 20 years. Section 6, aggravated. Yeah, my lord, there are certain discrepancies, my lord, in the evidence, my lord.
No, you said paper book is ready. You will hear it. Will appoint somebody and hear some.
All like it. For the bail, my lord, an early date may be given. Assuming 3 years is sustainable, my lord. 20 years, my lord, I respectfully submit. It may be a fit case for granting bail, my lord. No.
You have filed the bail application separately.
Yes, my lord. That is pending, my lord, ever since.
Where is that? There is an I.
At 32. A lot of evidential issues. Even there is an admission by the complainant that there is a land dispute with the accused. And that was also stated by some other PW.
Ms. Bhuya,
Lordship.
when was it served? Date?
Oh, Lordship, Espada enclosure, my lord, submitted along with that. 9/10/2025. The report, my lord, from the Inspector of Police, Lahore Ghat PS.
9/10.
Yes.
With, I would like to report that has been legally served. Therefore, notice is being returned. He has not said that was served on this day.
No, on the, yes, it is not there. His signature is there. And prior to that, there's a RTI of Anwara Khatun. Spare moment. I s-
Yeah. Mr. AC Borgmara, Learned Senior Counsel, appears for the appellant and submit that paper book has been duly received
Simple.
and that the pending bail application may be considered. Stop. Ms. B. Bhuya, Learned Senior Counsel and PPSM,
APPM.
APPSM submits that notice upon the complainant has been served. And the officer in charge of Gauhati Police Station has reported back by this communication dated 9/10/2020. Is it 25?
Yes, ma'am.
25.
None is entered it in so far.
She has also produced a copy of the said communication. Stop upon perusal of the same, notices except to be complete upon the complainant. Stop, since no one appears for the complainant, we appoint. Mr. Abdul Karim Azad as the legal aid counsel to represent the complainant. Registry shall furnish him the paper book, the copy of him, the paper book within 3 working days. This is the matter again.
Loshi, I have not been, I have not received a copy of the, maybe officer's misplaced date. Paper book is not available with us. Can the direction be given to the registry?
It can be given, but you have been served perhaps. A copy of the paper book, don't write. A copy of the paper book has been furnished to the additional PP for his oblique hard necessary use. Dated 12/8/20, 12/5/26.
By our office, maybe, ma'am.
You've misplaced it. Are you sure?
I have not misplaced it. Office might have, they do.
Might have.
Might have.
If-
They have not served on us today. That's why I'm submitting.
The date it may be fixed for bail hearing, that's all.
I think you should check
There's
up
no-
with your office.
Then, Losh,
If it's not, they will pass necessary orders later.
Only will go on, my lord, learned PP will be there, my lord, at least a date may be fixed for the bail hearing. There is no. The amicus curiae will appear, that is different thing. For the purpose of bail hearing, the date may be posted. That's my lord.
That is there, but the thing is that paper book is ready.
Right.
Amicus is going to be appointed, is already appointed.
Let them also be there.
We might as well hear the matter on that particular day.
Lordship may observe that if the minor hearing doesn't take place of. That is that observation, lordship.
This is the-
2024 matter. Lordship, please to fix it for hearing then, early date. It's up to the Lordship, up to Lordship.
Normally what is done? Date is fixed or for hearing?
Some cases dates are fixed, ma'am. And if they want to praise for IA, then Lordship may, I leave it to your Lordship.
That's what
Since
I'm
the
saying.
paper book is ready, your Lordship, matter may be hard and disposed of.
Keep it open, my lord. Lordship may keep it open. It is done. Their lordship.
Then we post it after 2 weeks then. All right. List the matter for hearing after 2 weeks. On a date to be fixed by the registry.
Date may be given.
Office will fix the date.
No, let it be on 23rd. 2 weeks, after 3 weeks. Let it be on 22nd. 22nd.
Okay, you, not 22nd, you will have it on 23rd.
Yes,
List the matter for hearing on 23rd.
yes.
Nineteen.
19th. This is,
Maybe M doctor, and doctor's name is shown as an amicus. Nobody's appearing. What's the last word of
completed. Not completed.
Or and doctor's name is shown, that's why he might have missed. Oh. Okay.
Amicus,
Oh, and NJ doctor's name is also not shown, my lord, in the cause list.
who is it?
NJ doctor's name is not
Appears
shown.
for whom?
Or R2 have not checked.
No, NJ Datta appears for whom?
Maybe for R2, your lordship.
One, Mr. N Datta is there, amicus curiae. If he is there, then. Question is, what about the respondent number 2?
Yes, my lord.
Kampur, yes.
Please say my list to prepare and postpone. As a notice has been issued upon the responsible of the person. That is.
Miss S.H. Bora had appeared last night.
Share of instruction. Yes, lordship, we need to take fresh steps then. I have no information and no papers available with me. Yeah, about it. Yeah, about it.
None appears for the appellant when the matter is called. Ms. B. Bhuyan, learned additional PP appears for the state and seeks further 2 weeks' time to inform the court about the status of the notice being served to respondent number 2. This again after 2 weeks. Guys, 5 minutes and come back.
Lordship in item number 19. Instead of N Datta's name, NJ Datta's name be shown because NJ Datta is appointed as an amicus. For that reason, he is absent. And the cause is shown as N Datta.
It should be what?
NJ Datta, not
NJ.
Datta. Yes.
Are you sure?
Yes, my lord. Same. The records.
Please write Ms. B. Bhuya, learned senior counsel. And additional PP submits that. In fact, it is Mr. N.J. Datta who is the appointed amicus curiae and not Mr. N. Datta. Considering the same, name of Mr. N.J. Datta be reflected instead of Mr. N. Datta as the amicus curiae. You just add this order, okay? Somebody had taken, Mr. Nimanta had taken. In item 19. This will be in addition to what he has already taken, okay?
Item 20, your lordship, although we took time to file objection, might not be filed.
Objection to what this IA for?
Is the IA, your lordship.
IA for?
IA for suspension of sentence.
Suspension.
My fact, one.
302.
Lordship, we have filed. For bail, you lordship for suspension as well as.
Objection by person.
Why are you asking him?
No, sometimes other PPs like,
You're asking whether you have filed objection or not.
not me, maybe some other councils.
Okay,
offers,
okay. Some others might have filed.
Yes.
You might not
But
have known.
please don't say so. We're not.
Okay. You have not received objection, correct?
Yes, Lordship.
You have not received, or have you received?
We have received the paper book, Your Lordship, but no objection been filed, Your Lordship, against the suspension.
I'm not talking about paper book. I'm talking about the suspension. You have filed the application for suspension of sentence. Has the state filed objection to that?
No, Lordship.
Not yet, no? So,
Short did be given?
all right. That's paid for by Ms. B. Brian, Learned Senior Counsel and additional PT. Further, how much? 4 weeks?
Yes, or some 4 weeks. I'll ask for 2 weeks.
2 weeks time is granted to file objection to the IA.
Filing objection.
List again after 4 weeks.
After 4 weeks, all right.
Matter is.
If the objection is not filed by the next date, court may consider to proceed in hearing the matter since the paper book is already ready.
We'll file.
Just an observation, that's
File.
it.
I'm for the recommend matter. There is no maintenance pending.
Hmm?
No maintenance is pending.
No,
Maintenance money. We have paid money
you have paid already.
already.
So,
I have something to say regarding IA 158, Lordship. We have filed an application under section 25 of Independence Act.
Mr. Counsel, you are wearing 2 badges. 2 badges.
My
Same-
membership, LSA membership and Gauhati High Court membership.
Oh,
I
separate.
have membership of 2.
I thought 1 badge, two
Lordship.
PC have got, 1 for your friend, 1 for you.
I was shocked immediately. Lordship pointed what has happened. I was shocked. I was submitting. Very sorry. Lordship.
It's shining, that's why I was
Oh,
wondering.
signing. Oh,
Yeah.
not sign.
Yes, so,
So my humble submission is regarding permanent alimony, Lordship. This matter can be solved in mediation center, Gauhati High Court, Lordship. It will be
mediation.
mediation, yes. If
How
the
much
case-
are you expecting?
No, we are expecting 30 lakhs.
30 lakhs.
30 lakhs, but on negotiation, it has been scaled to 10 lakhs. Order has been there. 27 to 26 order has been there. This Lordship order is there. Special important.
27 to.
27 to 26. Lordship order is there, but till date they are not followed this.
So you have scaled down from 30 to 10 lakhs.
10 lakhs, Lordship.
Opposite party says, I can pay only 5 lakhs.
Yes, ma'am.
So, maintenance has stopped from December 2024.
No, no maintenance is pending.
Now it
Maintenance
is,
is not pending now. Already been paid money.
no, monthly maintenance, there was
Already
area.
paid means,
Till this month, money.
it's a monthly
Monthly maintenance.
maintenance,
Ten.
isn't it? So you've been paying regularly.
Yes, I'm paying.
No, area was there. So till that, no area. Up to May, last of May 26, there is no area. So he has to pay in monthly. There was an area of 1,40,000.
Hmm.
So that has been already cleared
Yeah.
last May. Means yesterday, I think. Last week he has cleared. So
Okay.
now we are on the permanent element.
Yes.
So if that thing can be settled in the mediation, then it's because he is
Make
not
an
willing to
attempt.
give.
Make an attempt.
Yes, ma'am.
So this matter to send to the
2.0
mediation.
mediation is going on. 2.0. So Apex Court also is saying that
Yes,
it's try to
yes, special matters,
send as many as case possible
Yes,
in
ma'am.
mediation.
mediation.
Okay.
So
The learned counsel for the appellant submits that the respondent has cleared the area monthly maintenance. And the issue now to be considered is as in regard to permanent alimony. Stop. He therefore submits that the matter may be referred for mediation. So learned counsel for the opposite party also agrees to the same prayer. In view of above, registry shall send this matter for mediation without further delay by notifying the parties concerned.
Time. Then next, the released after how many, 1 month?
They'll notify. I said immediately.
So it will be in High Court. This
Of
will-
course, High Court only. Notice will come to the parties. They're informed.
All right.
What is appearing for the micro solution?
Sivsagar. No TCR. What is this appeal? Jail. It's also jail
looks
appeal.
like I don't have any papers.
Anybody has been appointed?
Yes, my KP Pathak.
KP Pathak is appointed.
Yes.
He's not appearing today. It is seen that TCR has not arrived. Office to send a reminder to the trial court consent to send the TCR immediately. None appears for the appellant, while Ms. Deeb here, learned senior counsel and additional PP appears for the state. This again on receipt with the TCR.
25 will file an objection against the IA and TCR has arrived, your lordship. Let the paper book be ready.
Who appears for the appellant?
Appellant,
I-
Mr. Jahid.
This is not from jail, isn't it? What about the number 2?
Number 2, Miss S. Sharma Hajarika, she is appearing.
You are the appellant?
Yes, please.
Okay. You are there? Okay, parties are represented by the respective counsels. And they submit that since the TCR has arrived, paper book will be prepared. Now, in view of above, office to prepare the paper book. Who will pay the cost of the paper book?
Personal capacity. There's not a jail appeal.
That's what.
Yes, ma'am.
Who will prepare the paper book? Registry
Registry to prepare, they
at the
may
cost of the appellant.
submit the cost,
Okay.
at the cost of them.
Registry to prepare the paper book at the cost of the appellant. And thereafter list the matter for orders once the copy is served to the parties concerned. What is this IE?
Or suspension of sentence.
Oh, anything to be said in suspension?
May not be, since my learned friend, whatever deliberation is made, he will not, at this stage, probably not pressing the IA. No, you said like, let the paper book be prepared. I don't know, what would be your submission. We have filed an objection.
You have filed.
Yes,
It doesn't seem to be there.
15/12/2025.
It's not here.
Copy by sir. Copy is also served.
Copy served but not filed. When did you file?
Lordship, 15/12/2025, my learned friend has received it on 6/1/2026.
You filed on 15?
My junior has filed it on 15/12/2025, but Mr. Jahid has received it on 6/1/2026, what? Oh, they did not before filing to Eastern, no. No, before filing one copy service. Lordship will verify it, like.
Yeah, you're right. This is an application praying for suspension of the sentence imposed upon the applicant. Ms. B. Bhuya, learned senior counsel and additional PP submits that objection has been filed to the IA on 15/12/2025 and copy served to the other side also. However, it is seen that the objection is not on record. Office to verify and connect the same to the record. This the matter again. along with the criminal appeal. Yes.
May it please your lordship.
Yes.
This is an IA in connection with the criminal appeal number 127 of 2025. This is an IA for suspension of sentence. This matter is listed for the first time. State may file an objection.
IA is thicker than the main appeal.
Madam?
IA is thicker than the main appeal.
Yes, madam.
Huh? There are more materials in the IA.
Yeah.
Heard, Mr.
P. Majumdar.
P. Majumdar, learned counsel for the applicant, who submits that by filing this application, the applicant seeks suspension of the impugned sentence imposed upon the applicant. Let notice be issued, returnable by 3
But,
weeks.
but I have checked the order sheet, one Mr. D.K. Vaidya was appointed in my class.
In which case?
My lord, this is item 26, my lord.
In the criminal appeal.
Criminal appeal, my lord. D.K. Vaidya name is showing also.
So, he's not here.
It's not here. But the wrong is shown for petitioners.
Is the amicus curiae for the appellant?
Amicus curiae.
For the appellant?
Perhaps, my lord, because his name is shown from this side, my lord.
So what is wrong in that?
May I check the office note, my lord?
No, he is appointed in the appeal,
Appeal, my lord.
order dated 24/10/25.
For informant. For informant.
Huh?
No, not fine.
No, to represent the accused appellant.
Accused appellant. Then, my lord. They are saying he is filing a wakalknama only in the IA. But that cannot be only for IA.
The appeal came from jail, that's the accused appellant contacted you to present me in the matter.
Yes, your lordship.
Hmm.
We file a wakalatnama for the IA.
You cannot file wakalknama only for IA. You have to file for both.
This we done for the entire case.
Entire case.
You representing the entire matter, you cannot representing the bail and all.
Amicus was obtained, but at the same time, we have also filed a wakalatnama for the entirety of the matter.
Yes, then amicus name.
Like us would say that since you are bringing this, but if you matter.
Yes.
Either you representing both of the matters, which is. Yeah.
Yes, so what do you want to do?
Represent the.
Only the IA front. IA. Appeal to amicus have been appointed. What did I say last, please? Mr. R. Kaushik, learned additional PP accept notice on behalf of the state. Extra copy will serve to you. What is this POXO case? Or what? Is it a POXO case? 302.
302.
302. 302. But this
The-
year not received, madam.
The state may file their objection to the IA if so advised. Next para, it is at this stage, it may be seen that this court had appointed an amicus curiae to appear for the appellant by order dated 24/10/2025. namely Mr. D.K. Badya. Stop the learned counsel for the applicant, Mr. P. Majumdar, submits that he has been engaged only for the IA. Mr. P shall therefore obtain instructions from his client as to whether he will be representing the appellant as well in the main appeal by the next date. Since there has to be proper coordination between the counsels to represent the appellant. List again after 2 weeks.
In the meantime, TCR may be called for.
That was already called for in the appeal.
We have not received them.
This order is in the IA only. Criminal appeal we're not touching.
Fine.
Because there's already an order for calling for the TCR.
Fine.
So maybe we can include that also.
Since it is not coming, so they might have.
In the main appeal, you write, since the TCR has not arrived, office to send a reminder to the trial court concerned to send the same immediately. List the matter again on receipt of the TCR.
Please, your lordship, we have served to the respondent by way of Dosti service and there is the speed post also. He received on 7/5/2026 Dosti service, lordship. We have filed affidavit on 12/5/26. Delay of 215 days.
Where is your affidavit?
Affidavit.
Okay. Annexure. When did you
with
serve?
Annexure 1 also.
Yes, what is the date on which you served?
Dosti service date
Yes,
7/5/2026, lordship.
7/5.
7/5.
What is the name, the respondent?
Lucky Deka. Lucky Deka.
Lucky Deka. 7/5/26. Phone number is also there. This one, no?
Phone number has been given, lordship.
I is for condonation.
Condonation of delay of 215 days.
How much?
215 days.
215.
Lordship. Earlier, there was a appeal file preferred by the respondent, lordship. That was disposed of, lordship. That was filed by him. He has come for reducing alimony amount, lordship. During pendency of that appeal, we have filed this appeal, lordship. And that appeal is dismissed, lordship. Main alimony 3 lakhs. Honorable court has directed to pay him. There was a cross case, lordship. Order is with me, lordship.
Who had filed the appeal? Lucky Deka.
Lucky Deka has earlier filed
For
appeal.
reduction of the alimony.
Reduction of, and we have filed enhancement of the alimony during the pendency of that appeal, lordship.
Okay. So this IA is for filing that enhancement, for
Yes.
condoning the delay in
Delay.
filing the enhancement.
Lordship.
Okay. What is to be done? He's not appearing.
But he has received, lordship. Delay may be condoned, lordship.
How?
He is well aware.
Husband has not come. Lucky's husband. So this is the first time it has come after you have served notice.
Yes, lordship.
I think we should wait for one more date.
Lordship. Then short day may be given, lordship.
Maybe you'll arrange somebody to appear on his behalf.
Lordship. Short date may be given, lordship. 2 weeks, lordship.
We'll make an observation. If he is not represented, we'll go ahead with the confirmation,
Lordship.
considering, you know. Ms. R.B. Bora, learned counsel for the applicant, submits that the respondent has been served by way of Dasti as permitted by this court on 7/5/2026. And he has also given his signature as a token of receipt of the notice. So she therefore submits that the delay of 215 days in filing the connected appeal may be condoned. Next para, no one appears for the respondent today. And therefore, we grant one more opportunity for the respondent to appear, either personally or through his appointed counsel. Considering the fact that the respondent had also filed an appeal for modification of the alimony, permanent alimony. Which is required to be paid by him to the instant applicant. Next, in view of above, list again. What is this? What is this?
Appeals order, Lordship. Filed by the husband.
Oh. It's okay. But when is it going to be listed? Oh, this has been disposed.
Dispersed, Lordship.
Oh, disposed already.
Already, that was, and we have filed this appeal during pendency of that appeal.
How it was disposed? Dismissed.
Dismissed, Lordship.
What is the last part I've said? In view of the fact that so and so, then not required. That delete not required. Since the appellant is not represented, the respondent not represented today, we are trying to give one more opportunity for him to appear either personally or through his appointed counsel. Okay, list again. Give a date after 2 weeks on 24/6.
Deeply obliged, Lordship.
It is also made clear that if no one appears for the respondent on that day, court may consider proceeding with the application for condemnation of delay.
Deeply obliged.
Lordship, an IA has been filed for the condemnation of delay of 2 days in connection with the MAT appeal.
MAT appeal.
Yes,
Notice will have to go.
only 2 days, your honor may consider,
Even if it's 2 days,
yes,
you have to file application.
yes.
Even if it's 1 day, still you have to file
Yes,
application.
Lordship.
So let notice go, let them come say. They may not object after all. What do you say, brother? Ordinarily, no one will object to this, but let the formality be complete.
Yes, Lordship.
Okay. Heard Mr.
DK Borderline.
D.K. Bodoloy,
Yes,
learned counsel for the applicant, who submits that this application is filed seeking condemnation of 2 days delay in filing the connected appeal. Against the impugned order dated 12/11/2025, passed in miss means miscellaneous, bracket J, case number 8 of 2025 by the Principal Judge, Family Court number 3, Kamrup, Gauhati. Next para issue notice returnable by 3 weeks. Applicant to take steps for service of notice upon the how many respondent?
but only one.
Then why do you write respondents
Oh, it is
upon the sole respondent
yes, the typographical
by
mistake.
speed post within 3 days? List again on so and so. Respondent may file objection, which advice. Completed. First day. Tomorrow is a hearing day, I think.